This is a video about Regulation 1071, access to the profession. Primarily it's about the action that is considered reasonable at the moment, and it's going to be aimed primarily at Wigan Council and the Traffic Commissioner's Office of the North West region. I'm going to take you through the particulars of claim so that you can see it, and essentially it's about these home to school contracts that the councils have given to Section 19 permit operators. We all know it's illegal, we all know they shouldn't be doing it, but they're doing it anyway. What can we do about it to stop it? Well, this is what we're going to do. I'm going to take you through it by page so you can see it yourself, and feedback's appreciated. You can see that the claimant is the company name given, and you can see that the first defendant is the Traffic Commissioner's Office in the North West. Second defendant is Wigan Council. The claims for negligence against both defendants, because both defendants owe the claimant a duty of care, have breached their duty of care and caused the claimant a loss. The claimant is in the business of providing PSV services under an operator's licence, and the first defendant is responsible for policing. The first defendants are the governing body of the claimant and are directly responsible for ensuring that the second defendants adhere to the provisions of Regulation 1071/2009. The second defendants are responsible for the home to school contracts issued to satisfy their obligations under the numerous education acts. The relevant law in this matter is 1071/2009, a copy of which is attached, specifically Articles 1, 2, 3, 6 and 7 of that regulation. As it is a regulation, it is directly applicable in all member states, and the right to enforce this regulation of the claimant arises from the regulation. Both defendants owe the claimant a duty of care, as both defendants are likely to injure the claimant if they do not apply Regulation 1071, as that regulation is specifically in place to govern the provision of the home to school contracts. In 2016, the claimant applied for numerous contracts, but numerous contracts were awarded to holders of Section 19 permits. In 2017, the claimant applied for 54 contracts, but numerous contracts were awarded to holders of Section 19 permits. In awarding the contracts to holders of 19 permits, the second defendant breached Article 1 of Regulation 1071. Further, the first defendants failed to ensure the regulation was adhered to. The claimant suffered a loss by both defendants' failure to abide by Regulation 1071, and claims for the loss of profits it would have had the contracts not have been awarded to holders of the 19 permit. The claimant tendered for contracts at a daily rate of £190, take off the running cost per day of around 50%, and the claimant was expected to receive around £95 per day as company profit. This is taking into account the common factors such as wages, fuel, wear and tear, corporation tax contribution, insurance tax, annual inspections, etc. The claimant intended on operating not more than 8 vehicles for the council that year. This is a breakdown of the losses. 8 vehicles at £95 a day profit gives you £760 per day. Multiply that by 5 gives you £3,800 per week. 37 weeks for the duration of the contract would have been £140,600. The losses from 2016 are yet to be calculated. An application to repopulate this particulars of claim is expected once disclosure and inspection of records is completed. The claimant agrees it may not have attained all 8 vehicles on contracts, but at the time of writing it is simply not known exactly how many tenders were in the pool of legal applicants. But when Section 19 permit operators are removed from that pool, only the pool of legal operators is left. The claimant sat in amongst the legal operators and would have, on a balance of probabilities, got all 8 of its contracts, all 8 of its expected allotment of work. The decision to award contracts to Section 19 permits breached Article 1 of Regulation 1071, and the claimant claims damages for this loss of profits on this basis. Statement of truth. I'd like to know what other people think about this. Is everybody else thinking along the same kind of lines? Has your council done the same thing? Put your comments in the boxes below and let's hear what people think. Thank you.